Welcome back. Hopefully you've already watched my previous videos on Akilah Obviously's copyright infringement case against Sargon of Akkad. Specifically, in the last video, we looked at Akilah's argument that Sargon's use had a negative effect on her work's value. And I made the case that, based on the evidence, the exact opposite was true. Sargon's video actually gained attention for Akilah's video, which leans toward a strong position of fair use in Sargon's case. However, as I've said repeatedly in the past videos, the courts insist at looking at all factors when considering fair use. And we still have the factor most people are concerned about, which is the transformative nature of Sargon's work. Before we get to that, however, we have one other factor to cover: the substantiality of the portion used. And the arguments on this factor lead directly into the transformative nature of the work. So let's dig into it. First, we should note the amount of the video used. Akilah's original video was about 10 minutes long, and Sargon's version of the video was about 2 minutes long. So Sargon used approximately 20% of the original video. Some people may consider this a substantial amount, others may not. As it turns out, according to the courts, there is no percentage test. In fact, you can literally use a work in its entirety and still pass the substantiality test for fair use. The Supreme Court opened the door for this precedent in Sony Corporation v. Universal City Studios. This case centered around Betamax video recordings, and the court found the fact that the entire work is reproduced does not have its ordinary effect of militating against a finding of fair use. The Ninth Circuit Court of Appeals later elaborated on this in Kelly v. Arriba, stating that if the secondary user only copies as much as is necessary for his or her intended use, then this factor will not weigh against him or her. The Supreme Court extended the scope of this test even farther for works of parody in Campbell v. Acuff, stating, "When parody takes aim at a particular original work, the parody must be able to conjure up at least enough of that original to make the object of its critical wit recognizable. What makes for this recognition is quotation of the original's most distinctive or memorable features, which the parodist can be sure the audience will know. Once enough has been taken to assure identification, how much more is reasonable will depend, say, on the extent to which the song's overriding purpose and character is to parody the original, or, in contrast, the likelihood that the parody may serve as a market substitute for the original. But using some characteristic features cannot be avoided." Adding later, if quotation of the opening riff and the first line may be said to go to the heart of the original, the heart is also what most readily conjures up the song for parody, and it is the heart at which parody takes aim. Copying does not become excessive in relation to parodic purpose merely because the portion taken was the original's heart. Sargon has repeatedly claimed that his version of the video was satire, and on at least one occasion called it parody. Under the law, these aren't necessarily interchangeable terms, and many people have argued about whether or not Sargon's video qualifies as either of these. However, those questions are part of the discussion on the transformative nature of the work, which we will cover in a later video. For now, the question is, assuming that Sargon's purpose was as he claimed, did he use only what he needed to make his point? Based on Campbell's broad leeway given to parody, I would say the answer is yes. However, while I would argue that Sargon has broad leeway in the substantiality of the portion he used, I don't think he actually needs it in this case. In Blanche v. Coombs, the Second Circuit, in examining the quantity, quality, and importance of the material used, looked to what the original artist considered to be the key aspects of her work. In this respect, Akilah's filing is instructive. It reads in various places as follows: Hughes had the rare opportunity to cover the live events taking place at Democratic candidate Hillary Clinton's watch party. She captured footage depicting the raw emotion of the crowd as attendees learned of the election results and began to process and accept what would ensue in the days and years to come with Donald Trump in office. Hughes filmed the unparalleled events firsthand. Over the course of the evening, Hughes captured the roller coaster of emotions that permeated the Javits Center, from the electric energy of anticipation to the crestfallen realization of defeat. She also contends that this footage is, quote, priceless, and that her video received immediate praise for its raw emotion. And in her video notes how difficult it was to get press credentials to even be at the event. The filing does mention her commentary as having value as well, but as she stated in her filing, she has uploaded a plethora of video content on her YouTube channel. To Akilah, the essence of her video, that which made it special, was its depiction of the raw emotions on that historic night. At the very least, this portion of the video constituted a large part of what Akilah believed was substantial about her video. However, as mentioned in my earlier video on the nature of the copyrighted work, this wasn't the focus of Sargon's video. In fact, he excludes almost all of that footage from his video, with the exception of a brief opening clip that essentially sets the stage for the context of the video. The rest of the video is just Akilah's commentary about how we're in a divided America, and it's obviously the other side's fault that we're divided because they're ignorant, racist, homophobic, etc. Returning to Blanche v. Coons, in that case, the Second Circuit Court found that given that the copier excluded much of what the original artist believed to be key aspects of her work, and instead only copied the portion necessary for his express purpose, that the substantiality of the copying was reasonable, and that it weighed significantly in the copier's favor towards fair use. As I pointed out in the beginning, a work that is considered parody has much more leeway in the amount and quality of the copyrighted material it uses. However, the quantity, quality, and importance of the material used will come into play when we discuss the transformative nature of the work in the next video. And since many consider the transformative nature to be the pivotal determining factor of fair use, the stronger defense of the substantiality of the amount used becomes important. But of course, I could be wrong. Feel free to tell me what you think in the comments below. Also, we've now covered all the main factors in a fair use case except the transformative nature of the work. Let me know where you're coming down on Sargon's case now. Are you for him? Are you against him? Have these videos changed your mind at all? And of course, as I've said in my previous videos, this is a brand new channel, and that means these videos making the legal case for Sargon aren't going to show up in anybody's feed. Obviously, Sargon can't comment on this case too much for legal reasons, and there's a lot of bad information out there that's damaging his reputation. If you think I've made a good argument and want to help spread the word, click the subscribe button and share these videos on social media. Thanks for all your help, and see you in the next video.